Hi, everybody. It's Aaron Emery here from Rent Roll Mastery, and I'm joined today by the lovely and very knowledgeable Sarina Gibbon from Tenancy Advisory. And if you don't know who she is, you need to jump onto Google and have a look. Thank you for joining me today.
Thank you. Thank you for having me.
So we're going to be talking today about a really hot topic. It's a little bit contentious, and it can either set people on a trajectory of fear and concern or excitement, depending on what they're going there for.
Depends on their personality type, right? Because some people are like, bring it on.
Yeah, exactly. Yeah. So we're going to be talking about tenancy disputes and tribunal. And I feel like it's fair to say that there's a lot that we can do to prevent us from ending up there.
Yeah.
But if we do end up there, Sarina, what do you think, what have you seen happen which can really change the outcome of that process when it comes to communication and what property managers say or don't say?
I am going to take your question back a step and answer it in two parts.
Okay. Go
so let's pretend that we haven't got to the tribunal yet, because ideally you don't want to be going to the tribunal. It's a lot of time suck. Definitely can feel like you're being dragged through the trenches, and it's not, I gotta say, in all my years advising on tenancy law, no one has ever come to me to say, I've become a property manager so I could go to the tribunal all day, every day, right? So it's not why people become property managers.
Yes.
Okay, so let's say we're in a scenario where there's something simmering. It could escalate to the tribunal and it could not. And I think this is the point where I see a lot of well-meaning property managers making fairly critical communication mishaps, which pushes the relationship one way. And that means there's really nowhere else to go but the tribunal.
Right.
Okay. I see a lot of property managers, when they think about what it's like to be professional, they all of a sudden, their default is to dehumanize that relationship and then go in with a 14-day notice or an email that is sternly worded, that is essentially them cosplaying as a lawyer, what they think a lawyer is or speaks like.
Yes. Which is probably written by AI.
Should probably written by AI.
Yeah.
And also, like, actually some of them are written by template providers from a time when that was quite common legal drafting. So there's some legacy templates floating around in the industry.
Yes.
That really goes in hard and communicates in a way that's very, very adversarial. That all of a sudden, and you know, from the tenant's point of view, it's a little bit psychotic, right? Because you're dealing with a normal human being, you're dealing with a normal property manager, you're speaking plainly, you're doing well, you're kind of like, you know, you got your mojo and it's all good. And all of a sudden, because you didn't close the curtain a certain way and water came in or whatever, you're at the receiving end of this kind of like quasi-legalese email that talks about, oh, I can apply to the tribunal to terminate this tenancy, that peppers in certain 3-syllable big Latin words that you don't really know what it is. Right. And you're just like, you don't know who you're dealing with, right? And that just gets people's back up.
It's like pulling the pin and throwing the grenade.
Yeah, it's just kind of like, I always say to people, try as much as possible, be consistent with how you communicate with people.
Yes.
Because when things are not consistent and people think that they're dealing with like a psychopath, that's when they go into defensive mode and go, okay, this relationship isn't what I think it is.
Yes.
And I gotta, you know, and that's when they become unpredictable. It's like, think about
it's that fight or flight.
Yeah, like think about backing a cat into the corner. I'm not a cat lover. I'm a dog lover. So I'm always going to trash on cats. Sorry.
Me too.
But like, think about what happens when you back a cat into the corner.
Yes.
Right?
What's it going to do?
Yeah. So I think to me, what's a critical mistake I see property managers make all the time is the propensity to dehumanize their communication and dehumanize their approach to whenever they have a whiff of problems.
Yes.
Rather than just being human and go, hey, listen, this isn't kind of jiving well with me. Can we maybe sort of figure out a solution together so that we're not stepping on top of each other's, right? And if you want to give 14-day notice, if you want to give like templates, use templates, I always say to people, there's nothing wrong with using the government's template that you can download from tenancy.gov.nz. There's this tendency to think that if you spend money to procure a private vendor provided template, it is somehow more legally enforceable than the government one. When the truth is the reverse, it's the opposite.
Yes.
It's like there's no world where the Tenancy Tribunal is going to strike down a tenancy services template.
Yes.
But there's just some horrendous tenancy agreement templates and tenancy notice templates out there that are privately provided for a fee that do not serve the purpose and sometimes inflame the relationship.
Yes.
So
I've seen that before.
Yeah. So that's number one is let's just dial the temperature down and don't be psychopaths.
And maybe just even apply a little bit of more empathy. Like I always say, it's, how you have the conversation with the tenant determines the outcome.
Yeah.
Like you can say to them, hey, I'm really sorry that you're having this situation and you're going through this period in your life. I just want you to know that we understand that it must be tough right now for you. When we're angling it to the legislation says that it has to be X, Y, and Z. And so I just want you to know that if that kind of behavior or pattern continues, then you're going to force my hand and we're going to have to,
I'm going to have no choice. But if you go to the legislation straight away and you kind of like dehumanize the relationship, the biggest risk to a practicing property manager day to day is a tenant who feels like they have nothing to lose.
Yes.
Right?
Yes.
And you don't want to encourage that.
No.
So as much as possible, treat the law as bare minimum safety net that you can fall back on, use creative thinking and a lot of humanity and empathy to work with your tenant to get a solution that is going to work for everybody. So that's number one mistake I see people make before they get to the tribunal. Now, I will also say this. One thing that I'm incredibly proud of is when people ring me up to get advice on a pending dispute or like a pending hearing, my first instinct is always, have you thought about ringing the other side and making it go away? Like, have you thought about just picking up the phone?
Yes.
And to say, hey, listen, what is going to make this go away? I've even built into my regular tribunal and dispute management training, like indicators to show property managers, what are some of the features and characteristics of a tenant and their circumstances that's going to make them more likely to come to the negotiation table with you and help you resolve a matter and rescind the application to the tribunal.
Yes.
Because when you can have those collaborative problem-solving experience with a tenant, you can come up with solutions that are over and beyond what the RTA has set for you, right? Because what the RTA, like any other pieces of legislation does, is it sets a minimum floor for your obligations and it sets a ceiling for your rights, right? And when I see people come together and negotiate their own outcome and they can hold each other to, like sometimes you can go beyond the ceiling the RTA has set for your rights. And sometimes you could even probably go below that floor for your obligations. So there's just a lot of creativity, I think, is such an undervalued feature in this industry. But once you get to the tribunal, the number one mistake I see people make is inconsistent and lackluster or insufficient information.
Evidence.
So last time we spoke, I mentioned about the difference between a knowledge asymmetry and an information asymmetry.
Yes.
Right? I talked about, as a practicing property manager, you would like to think that the knowledge asymmetry is always going to be in your favor because that's your business. That's what you practice day in and day out. And you're going to know the law better than your tenants and your owner. You're going to know the property better than the tenant. You're going to know the potential of that tenancy better than your owner. That's a knowledge asymmetry, and that's hugely valuable for your day-to-day practice. But when it comes to the tenancy tribunal and you got to present your case to the tribunal, that's when information asymmetry is really going to be the differentiator between who's going to come out feeling great from that hearing and who's going to come out feeling like, oh my God, I'm going to have a massive money order against me, right? And I see the mistake applicants make when it comes to the quality of information is they tend to either give too little information to help the adjudicator understand the dispute through their lens, or too much information as to make it almost impossible for the adjudicator to understand the dispute through their lens.
Yes.
Right? So it's flooding or it's starving.
Yeah.
And it's kind of figuring out what's the middle
balance.
ground, right? I do a lot of tribunal dispute resolution training. And I often do this exercise of saying to people, tell me the story of Snow White. And then I tell them a version of a story of Snow White, which is basically oversharing. I talk about what did Snow White have with breakfast that morning? And what was the color of the headband on her that day when the wicked stepmother decided to give her that poisonous apple? Like, I put in all these useless information and I sort of help people figure out how difficult is it when you chuck all that information in? How difficult is it for people to follow the point of the story of Snow White?
Yes.
Right? And then I take that same story and I strip away a whole bunch of information. I strip away things like the stepmother's jealous of her beauty. Again, if you hear that version of Snow White again, it's really hard to understand what's the story trying to tell us.
Yes.
Right? So to me, the art of doing well at the tribunal, part of it is understanding how much information do you have to feed to the adjudicator and the party on the other side. And how do you feed that? And what's the right form and format to feed that information across effectively so that you can almost, in a way, control the outcome of that hearing.
Sure. So it really has to be relevant information. You need to be able to outline exactly where the tenant may have breached a certain component of the act, and don't fluff it and don't add the non-necessary information that might just inflame the situation. Because ultimately, when we go to tribunal, we are looked as the professional that should have more knowledge, better understanding.
And don't squander that. Right? You do have more knowledge. You do have better understanding. Don't squander that.
But when we walk in and we come unprepared, or we don't know the facts, or we've clearly breached a part of our own obligations and we're not aware of that, that's where I see them, usually falling apart.
Yeah.
Because the tribunal adjudication member is going to look at us as saying, you should have known better. Why did you operate that way? We can understand why the tenant is disgruntled or upset, or, we can understand that they may not have taken it seriously because you were not working in line with the regulation or the, tenancy laws. Yeah.
And I think there's a lot to be said about, in applications these days, more and more they're complex. They're not single issued. They're layered. Most applications I look at would have a cross application on top of that. And I tend to be of the view of, because you have so little time in front of the adjudicator, because they're very good at scheduling these hearings. They're very economic strategic with their time, with how they prioritize cases and the times they allot. Because you have such limited time, I always say to people, for the low-hanging fruits, for things that you blatantly did wrong and there's no coming back from, just clean it up before the hearing. Yeah. Right?
Don't even go there.
Just if part of the tenant's application against you is, I asked for a rental summary and they never gave it to me, just give it to them before the hearing. Because that's such a black and white, low-hanging fruit issue that it's not worth fighting over.
No.
Right?
And why would you withhold that
just
anyway?
Just like that. Look, we all screw up. I screw up 10 times before lunch every day. That's pretty normal for me. I think sometimes it's just kind of owning that and going, I effed up. I fixed it.
Mm-hmm.
Take accountability, like admit, take accountability for it,
Mm-hmm.
fix it, ideally before the hearing, so that come the hearing, you can sort of say, hey, Mr. Adjudicator, thank you for your time today. I just want to assure you on this matter, yep, it was our oversight. We did wrong. We fixed it before the hearing.
Mm-hmm.
And I welcome your views on what would be an appropriate penalty for it.
Yes.
And just let that go, right? If you can't fix something before the hearing, show contrition. Again, low-hanging fruit, things that come with a small price tag,
Mm-hmm.
things are just really black and white. There's not much gray about it.
Mm-hmm.
And that clearly you're in the wrong. Don't double down. Just go, yep, it's me, messed up. Let me clean it up.
Yeah,
right?
Because I would think that the member is going to have greater respect for you if you can show that you've tried to negotiate and mediate and deal with the matter.
And also, from a practical point of view, you want to give yourself more time in that setting
Mm-hmm.
to really fight for the things that matter, right? If the tenant is making a retaliatory termination application against you, the potential penalty is thousands, right? So you really want to get rid of all these tiny minutiae of issues
Mm-hmm.
so that you can spend the most of that adjudication, really have a robust discussion and debate about whether in fact your termination notice was retaliatory,
Mm-hmm.
right? Because
Yes.
sometimes, it is like present on your mind, but there are instances where circumstances are just lined up in a certain way that really your termination notice, despite coming after a tenant exercising a right against you or making a complaint about the tenancy to you, that it actually has nothing to do with the tenant's right against you.
No,
It's
so
something that
it's not retaliatory,
pre-existed.
but it
So and that's, I've seen it over and over again. And you want time
Mm-hmm.
and you want the adjudicator to not spend any of his or her mental load on these tiny insignificant issues,
Yes.
so that you give your big issues the best chance to end up in your favor.
Yeah, because I have a question for you actually, because in Australia and like at least, in Queensland where I am from, our tribunal members, our adjudicators, they will make it very known that they want to know that tribunal is the last option, not the first option. So they want to know that you have tried everything possible to negotiate and mediate and resolve the issue yourself. And if you walk in there going, no, we're just not interested. Yep, the tenant reached out and they wanted to come into the office and have a meeting and we just wouldn't have a bar of it, the adjudicator is just going to go to town on you because you're wasting their time. If they think that it could have been resolved if you had have just come to the party and been a little bit more understanding or accepting of negotiating and where you're going to give and take on certain things and trying to reach mutual agreement, then if you haven't done that, then usually it's going to be a worse outcome for the agency. Is that what you see here in New Zealand?
I don't see it as such, and I think it speaks to our systems being structurally quite different.
Right.
I don't see it. I kind of see it a little bit, but not in the way you describe. So how it works here is when an application is put through, the tenancy services that manages the applications streams it down to either the mediation route or the tribunal route.
Right.
So mediation, you get assigned a mediator. The mediator doesn't lead the discussion, but rather facilitates and enables the parties to come to an agreeable outcome. They then document the agreement, and on your request, they can send it back to the tribunal to get it sealed, and that gives it enforceability. Being streamed down mediation doesn't necessarily mean you have to have a mediated outcome.
Okay.
You could try, you could participate, and if it doesn't work out, doesn't work out.
Okay.
And you go into the queue to get a hearing.
Yeah.
We have, within our tenancy law, we have a specific section 85 of the RTA, that gives adjudicators, it is actually my favorite section of the RTA. It gives the adjudicator a lot of breathing space to give them, to give merit to a party's position based on the principles of natural justice.
Okay. Yeah.
So it is an enabling provision in our law that says to adjudicators, despite all of these strict rules and procedures we have put throughout this piece of law, you are able to step away from all of that, look at the entire situation and assess the relative merit of both parties and figure out where the substantive justice sits. And you have the ability to rule on that. And it is, I would say it is probably the section that frustrates property managers, landlords, and tenants the most.
Right.
Because it is possibly the source of the most amount of uncertainty that comes through. But to me, when I look at the whole system and what it means to enable dispute resolution in a way that's broadly just, relatively cheap, and effective,
right,
without forcing people to go to court, I think it's a stroke of genius. Actually, that's my favorite section of. But then I say that because I'm a bit of a tenancy law nerd and I like to read stuff. So I like to figure out what adjudicators are thinking and how they're analyzing things.
Yeah.
I take it that that's not why people enter into the profession of property management. So I guess, to answer, going a long way, so coming back to your question, sorry, I'm very inarticulate today.
That's all right.
A long way back to your question is my view is it should be a very pragmatic approach to dispute resolution nevertheless, because when you can negotiate and when you work collaboratively with the other side to the dispute to achieve an outcome, I mentioned before, you can potentially get something that's more than what the RTA will give you or less than what the RTA is going to make you do. Right? You're not locked in.
Yeah.
You're in control of your destiny. You're not relying on a third-party adjudicator who you have no prior relationship with, who you have one chance to make an impression on them, who have this overwhelming power of Section 85 behind them, right? And you have no control. You do have control, but you don't get the final say over what that order is going to look like. And that's a judicial order.
Yes.
Right? So I guess from my point of view, it's I'm less worried about the optics to the adjudicator come the time of the hearing. I'm more worried about how impractical it is to not at least entertain some form of negotiated outcome, right? The one of the enduring frustrations practitioners have about our tribunal system is the long wait time.
Same.
So why would you wait when you can potentially get an outcome yourself? Right? And if you know the right legal mechanisms and the apparatuses that are available to you, there are some guardrails that you can rely on to ensure that you can continue to hold each other to account. Right? So I do think, going back to my previous point, I do think creativity is significantly undervalued in this space.
Yeah.
I highly encourage those people who are frustrated by the tribunal system to, as much as possible, think about how you can take back control and in appropriate circumstances, understand that you're not always at the tribunal's whim. You can potentially get out of disputes
and resolve
on
it
your terms.
Yeah. Yeah, if you're just willing to resolve it and negotiate and
and I just think I'm a big fan of people not spending money on my business. Very counterintuitive.
I think it's important that we make sure that we're educating our landlord clients too, right? Because sometimes it is the landlord that's pushing you to go to tribunal and no, take it to tribunal, it's the only way. And we need to get better at even educating them, going, hey, based on our experience, we've been there before for this similar situation, and this was the outcome, and it didn't go in the landlord's favour.
And a lot of it is sunk cost for the property management company.
Yeah.
Right? Like I've sort of come across quite a lot of situations where the landlord is almost like browbeating the property manager into taking a matter to the tenancy tribunal when it is so counterintuitive and so against the management company's interest. And really, if you weigh up what the landlord stands to gain at the end of it, like I've even seen situations where the landlord wants the property managers to pursue something that's less than $300 and walked away with a $16,000 order against them.
Wow.
Yeah. And it's just so insane that, and I think, again, this goes into the economics and the structural setup of these management relationships that managers have with owners. Is one of the growing aspects of my business is rewriting people's property management agreements, because these agreements are just no longer fit for purpose for the business in the 2026 context. And one of the common stresses when I interview my clients, when I do my discovery calls and I say, how do we figure out how this new management agreement is going to serve you the best? What is your enduring frustration with your previous agreement? What are your enduring frustrations with your owners from a relationship point of view? I have to say, Aaron, like 9 times out of 10, it is being told to go to the tribunal and being told to take a very adversarial position by the owners when the property manager is just like very reluctant to do so. They know that it is not commercially pragmatic for them. They do it against their wishes, but there's nothing in the PMA that provisions what happens if the management company disagrees with, to what extent can a management company have control of that process. I've even seen management companies where at the end of a tenancy, the landlord took the management authority away from the management company. But because there's an overhang of a tenancy, they nevertheless instructed that company to take the tenant to the tribunal. And I'm sitting there going, but you no longer have a relationship. You're no longer the agent of this tenancy. So where's, do you even have standing to take the tenant to the tribunal as an applicant? I get that if the tenant had made an application against you and you're the respondent in that case, you should participate in the process, even if you have lost management of that property. But if you've lost management of that property, should you then still be an applicant to the tribunal? I don't think so. Yeah. But because but a lot of people don't know what to do because their management authority is silent on that situation.
Doesn't outline.
Yeah. And then you have an owner who perhaps cynically, perhaps innocently understand that it costs them nothing to make the property manager go to the tribunal for them, because so many PMAs don't charge. Yeah. And look, should you charge, should not charge, it's a business decision. I'm pretty agnostic about it. But it's because it costs the owner nothing, because they have no skin in the game. It's really easy to do the battle cry when you're not on the front line. Yeah. Right?
To your point, though, where you say that, you often see where it is the landlord that's pushing and saying, no, do it. I think that could be a barrier point if more agencies were charging, so that, then the owner's looking at it going, if it's going to cost me $399 plus GST for you to go to tribunal on my behalf, and it's only for $300, is it worthwhile?
Yeah, so you're talking about the concept of hurt money, right? Yeah. And I think hurt money is a good short-term solution. I'm always a big fan of, in my head, I grapple a lot with the differences between how do you disincentivize somebody from doing something you don't want them to do versus how do you incentivize somebody from doing something you want them to do.
Yes.
So, and to me, those are two very different concepts. And and I feel like a lot of times when I have tension with people, when I disagree with people, I tend to disagree on this point is, to me, there's a big difference between putting in barriers to stop someone from doing something you don't want them to do versus enabling someone to do something that is aligned with your purposes and your vision and your approach, right? The former is very short term.
Right.
It's not going to work forever. The latter is more enduring. It's a more enduring solution.
Yes.
So yeah, by all means, pop a, and don't get me wrong, like I purposely price my services a certain way because I don't want to, there's certain pieces of work I don't want to do.
Yes.
There's certain people I don't want to do it for. So I price myself a certain way to make it it's a, what do you call it? A gateway control.
Yeah, correct.
Right?
Yeah,
and I think
doesn't come...
in a way, you could do that with your approach to whether you want to charge, how much you want to charge for tribunal attendance, what's the manner, like how are you going to charge for that? How are you going to pass on the costs? Some people when they come to me for advice, they pass that cost on to their clients. Some of them absorb it. It's, again, business decision.
Yes.
However, I do think when you have regular touch points with your owners, when you get your owners trained and informed enough into your way of doing business, when you get them buying into your business values and your approach, and you get their trust, it's so much so that every time there is a dispute simmering in the background, your owner, instead of thinking, I know what outcome I want, and I want Aaron to go do it for me, and I want Aaron to suck eggs. I want to teach Aaron how to suck eggs, right? Rather than, I know the outcome I want. I just want to tell Aaron, hey, Aaron, I just want to get to this. You get me to this.
Yeah.
However you get me there, I don't care.
Yes.
But get me to where I want you to get me to.
Right.
So when you have that relationship with your owner, where you're giving them value-add educational opportunities, where you are being very transparent and open about what the big picture looks like for you, why you are for them, and therefore why they should be for you and your way of doing things, then you don't even need to have that money discussion around, this is going to cost you $500 for me to go to a tribunal. This is the attendance fee, right? So I think it's a bit of kind of maybe both, because the way I see it is, when you price that number wrong, go back to the short-term solution of pricing in an attendance fee for tribunal participation. When you price that wrong, you turn people off from signing up with your business because it looks like, oh, so they want to charge me 10% for management. They want to charge me this much for inspection. They want to charge me this for going to a tribunal. And by the way, a lot of owners I talk to feel that when it's a compliance shortfall that results in a tribunal dispute, that should be all on the property manager.
Yes.
Right?
Yes.
And what is super interesting to me is so many management companies I talk to, when I say, hey, you really need to look at redesigning your indemnity clause, because some clauses I've seen are just not enforceable or partially unenforceable, that the courts are going to cleave that out anyway, right? So it doesn't give property managers the protection they think they get. So many property managers rely on these big net indemnity clauses, thinking that it's essentially a all clear, no responsibility relationship, which creates an optics issue for this industry as a whole, because you're essentially telling your clients, your owners, I'll do my best, but I'm not accountable for any mistake I've done. It's on you. Then the owners are looking at this going, why is it on me?
Yeah.
You just sold me a bill of goods that tells me you're so good at compliance. You know tenancy law better than I do. You know business continuity better than I do. So I give you 10% of my income each week or whatever it is. And you're telling me that I have to wear your mistake, right? And that's just not starting.
It's not going to sit well.
Well, yeah, it's just not starting the relationship well, right? Yeah. So again, business decision, if you want to build attendance fee in there as a bit of a gatekeeper of basically the subtext is saying to owners, don't waste my time, then at least make sure that that is how you message it clearly at the outset of the relationship.
Yeah.
If you're giving a lot of property management companies I talk to, they meet the client, they talk about their services, and then when it comes to conversion, they go, here's our contract, take a look at it and sign, I'll sign it and return it to me. And they never hear from the client again. I speak to a lot of those clients who never contact you again. It's because the terms just look like BS to them.
Yeah.
It just looks like you're about to trash them.
Yeah. And do you notice too, because I see this a lot in the, like on the Facebook group pages and channels with property managers, often they're out there kind of almost wearing tribunal as a badge of honor. Oh, we go 4 times a week or 7 times a week. And I'm like, whoa, red flag. For me, if you're at tribunal more than once a week, that is not probably...
It shouldn't be more than once a week.
It shouldn't be, but sometimes it happens. That's a reality. I talk to some property managers and they're like, oh yeah, last week I went to tribunal 4 times for these matters. And I'm thinking, why? Why are you there? And I often have people say to me, Aaron, do you do tribunal training? And I'm like, oh, look, I can stop you from getting there. But once you're there, you need to ring Sarina.
I can also stop you from getting there.
Yeah.
But no, it depends, right? It depends if you're there as an applicant or as a respondent. And this is where I hope the people who are out there listening to this was not a property manager, but you're a landlord or a tenant trying to figure out if the property manager is the right company to be working with. I will say this. Always do a tenancy tribunal search. Search the agency's name and see if their name appears as the first name or the second name on the case number, on the case names.
So respondent or applicant.
Yeah, respondent or applicant. And you can look, you can look at it both ways, right? So if you're an owner and you see, if I'm an owner and I see that an agency is always an applicant, they're always, to me, I'm like, why do you need to rely on the tribunal system to enforce your rights? Because when you're an applicant, you're enforcing your rights, right?
Yes.
So why are you always defaulting to the tribunal? That's a warning. That's a flag for me, because that's telling me you cannot, you have no control of your house, that you need to bring in a third party adjudicator to be the traffic cop for you every time.
Yeah.
So you're not in control of your operations. That's a problem for me, right? If you're always a respondent, I will look into it a little bit more. That tells me there's a tenant selection issue and a tenant relationship management issue.
Yes.
There. So either way, I'm personally not thrilled by it. I understand that some investors have a very particular view about the power dynamics between the tenant and the landlord, and they gravitate towards, or they're more aligned to, a very adversarial approach to tenancy management relationship, and that probably jives very well with them. It's a sort of energy, if that's the sort of energy you send out, then that's the sort of property manager you're going to work with. And that's how the free market works, right? It's your prerogative. But I'm by nature a conflict averse person. So when I see a property manager boasting about having extensive tribunal experience, it just tells me that fundamentally they're not running their business well on either side of the equation.
Yeah.
If I'm a tenant, I would look at if the property manager is often an applicant, then I would read that as this is a property manager who defaults to system and processes over relationship. And if you are that sort of some tenants don't want to have a personal relationship with you. They want this to be business. They don't want to chit chat with you and tell you about, oh, I'm expecting a baby and I'm doing they don't care if you treat them as human or not. Some people don't care. They just see it as it's a transaction, it's business. Sure, fine, whatever. I don't I don't mess with you, you don't mess with me. The line is clear. That's great, right? So that to me, if I'm a tenant, that's a signal to me. If I'm a tenant and the property manager is often a respondent, that's a massive red flag.
Yeah.
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 So it depends. If you're out there on social media staking this as a selling point, then you best be sure that the sort of business and energy you're going to attract will be a very adversarial and process-driven one that isn't about people and relationship. It's your prerogative. That's how you want to run your business. There's a demand in the market for that sort of approach. Yeah. That's no judgments. Great.
Yeah. I mean, I think I speak for myself. When I was a practicing property manager, I very confidently can go to tribunal and win a case and put a point forward and fill out the application and provide sufficient evidence to support the matter. But in my entire now 21-year career, I've been to tribunal 3 times. And people would say to me, Aaron, you just got lucky. But I actually dispute that. I would say no. I was really good at being able to mediate and negotiate the matter before it got there, but also have the right processes and practices in place to make sure that I never got there. And so the 3 times I did go, it didn't matter what I did. It was out of my control. It was going to end up there. 2 of them were during COVID. And so I think if we adapt that mindset that, you know, we need to look at making sure that we're running our businesses with the right processes, procedures, and steps in place to prevent us from ending up in a tribunal situation, then that's something that we should wear as the badge of honor, that we've only ever been there a handful of times. Like, Mr. and Mrs. Landlord, if we have to go there, I'm confident in how to get you through it. And I can give you the right guidance, and hopefully we'll win the case based on the evidence that we put forward, because we've got all of our ducks in a row and we've done everything right because of the processes that we have. But in actual fact, I'm really proud that in my 21 years, I've only been there twice or 4 times.
Yeah. And this is the thing is, I don't think property managers should be, I don't think it is a credible KPI for property managers to sort of say, I've attended tribunals this time and this number of cases came out in my favor. And, you know, I just don't think it goes back to what I said before. Nobody got into managing properties or owning rental properties to do dispute, right? Like, you probably go become a lawyer so you could do dispute because that's something you're drawn to. Yes. But nobody got into owning rental properties or managing rental properties to have fights with people. Right? That's not the primary purpose of what you're doing. That's an ancillary feature of having a rental business or managing a rental business.
Yes,
right.
Exactly.
Because it is a people business, it involves people, it involves different perceptions and sometimes expectations, and conflict is so inherent to relationships that, you know, that's part of the job, but that's not the job. Right. So I think from sort of the way I'm inclined and what I'm drawn to is more around when you're messaging to your clients and talking about how great your business is and why they should come on board with you or why they should stay with you. You should be talking about, you know, despite changing circumstances, we're able to accommodate your requirements alongside the tenants, and look at the longevity of these tenancies, despite, you know, like with a tenant who perhaps got into the tenancy as a young working professional couple, got married, started a family, and sort of grow, like the tenancy grows with the tenant. The tenancy grows with the owner.
Yes.
Right? The longevity, the strength and length of it is, you know, that it's being able to say these are the wins despite all the bumps in the road and the disputes that we talk about, whether it goes to tribunal or not, whether it ends after a couple of terse email messages. They're just bumps in the road. Yeah. They're not part of the story. It's like at the end of your life, Aaron, do you want to, this is getting very philosophical, but at the end of your life, do you want to look back to say, I won this number of fights?
No, of course
Or
not.
do you want to say I helped this number of people?
Yeah.
And I did
The latter for sure.
Yeah. So, and I think dispute resolution, whether it involves a tribunal or not, is definitely a critical skill set property managers should have. People who come to me for help, who's never had any tribunal experience, and I hold their hands through their first one, I always feel like they come out a different person.
Right.
Because you learn so much. Like, I don't think it's a good thing for a property manager to never go to a tribunal.
No, I agree.
Because it's a massive learning experience.
Yeah.
Right? You learn so much. And I think it's in that respect, it is fantastic. But should you be drawn to it insofar as, you're always gunning for it, always craving it? Yeah. It just distracts you from the business purpose.
Absolutely. Plus, I mean, how draining on your time and your mental health and taking you away from other more dollar productive, things in the business. Yeah, you don't want to be there every week. We need to wrap it up. But before we do that, I'm just going to give you a quick plug because you have an upcoming in-person event. Is that right?
Yes.
Okay.
I have an upcoming in-person tribunal masterclass. It's going to be at the end of June. It will be in Auckland. A few agencies had talked to me about taking it out of Auckland. So keep talking to me about it. I am going to be in a few other places doing private events. But public event in Auckland. There are only a few tickets left, but it is going to be 3 hours of fun, as fun as tribunal preparation can be. And we're going to do a lot of interactive activities to really get your head around how to be really effective and strategic with your approach to tribunal hearings. We're going to talk about AI. Because there's going to be, it is a trend that people are relying on AI to write their applications. Again, I'm very agnostic about it. I don't take a particular view on whether an AI drafted application is a good thing or a bad thing, but but
it's reality, right?
It's a reality, and you just deal with it.
Yeah.
And but there are particular ways that you could deal with it in a very effective way that doesn't make you lose sleep. So we're going to talk about AI, and then at the end of the session, we're going to use the new MEF rules that just that went live on the 16th of April this year. We're going to use those MEF rules to run a scenario dispute.
Okay.
And we'll just.
And if the listeners would like to get tickets, they just go to your website?
Just go to my website. We'll try to link it into this video.
Yeah.
And I'm a terrible promoter of events. But the point of it all, guys, is two things I want to say about it. First of all is I want it to be really, really fun and engaging. So I've kept the room really small. And I think there are only maybe less than 10 tickets left.
Okay.
Because I don't want it to be a circus. I just want it to be a pretty premium experience for people. And the second thing I really, really want to plug is I'm going to have my good friend Ali, who runs Lebanese Grocer in Auckland, cater the event. I'm so enthusiastic about his business. And also my very good friend Jess, who is a beautiful ceramicist. She's going to do the swag for the class. So I'm big on like not giving out shitty swags at events. So so there'll be something practical there as well. Yes, the beautiful and wonderful Jess is going to come and make barista coffee for everybody, and you get to go home with your handmade tumbler.
Amazing. Wow, what a unique gift. Yeah, that's great.
I'm so excited. I'm going to share it. Like, she just sent me the video, like all the cups just came out of the kiln and they look so good. I'm going to keep some for myself. They look so good.
I want one, please.
Yeah, I'm going to save one for you. It's got like my logo in pink on the inside. So once you finish your coffee, you'd like see my logo, but it's not like on the outside because I'm not going to make you market my business. It'll just be like a little secret between us.
Just subtle.
Yeah, I'm so excited. I'm so excited to introduce people who I like, great business owners who I love, who I like, just think they're fantastic. I just think Ali and Jess are just top of their games. They just got such refined taste. And I'm so excited that I have the opportunity to showcase their businesses.
Amazing.
To you guys.
Well, thank you so much again, Sarina, for joining me today. And thank you to our listeners and viewers out there. We are very grateful for you tuning in. And we have much more to unpack in more episodes, so stay tuned.
Thank you.